Copyright law deals with the rights of intellectual creators. So intellectual creators, copyright law deals with particular forms of creativity. It is concerned primarily with mass communication. It is also concerned with virtually all forms and methods of public communication, not only printed publications, but also such matters as sound and television broadcasting, films for public exhibition in cinemas and others, and even computerized systems for the storage and the retrieval of information. So copyright deals with the rights of intellectual creators in their creation. So most works, for example, we have books, paintings, or drawings, exist only once they are embodied in a physical object. Okay? That's the normal literary works that we know of. But some of them exist without embodiment in a physical object. For example, music or poems are works even if they are not, or even before they are written down by a musical notation or words. Okay, so copyright, it is the legal protection that we extend to the owner of the rights in an original work. Okay, copyright law, however, protects only the form of expression of ideas and not the ideas themselves. Okay, so from this first portion, I attempted to actually highlight concepts that you should always remember as you try to follow me in the discussion of the next slides. Copyright, original work. Okay. Original work refers to every production in the literary, scientific, and artistic domain. Among the literary and artistic works enumerated in the Intellectual Property Code includes books and other writings, musical works, films, paintings, and other works, and computer programs. So the creativity protected by copyright law is creativity in the choice and the arrangement of the words, the musical notes, colors, shapes, and so on. Copyright law protects the owner of the rights in artistic works against those who copy, that is to say, those who take and use the form in which the original work was expressed by the author. Okay? Works are protected by the sole fact of their creation, irrespective of their mode or form of expression, as well as their content, quality, and purpose. Thus, it does not matter if, in the eyes of some critics, a certain work has little artistic value, so long as it has been independently created and has a minimum of creativity, the same enjoys copyright protection. So this slide attempted to answer, okay, what are copyrightable works? Basic principles in copyright. Copyright is acquired by the mere creation of work. This is essentially different from trademarks and from patents. No formality is required for the acquisition of copyright, and therefore the present rule is also known as the no formality rule. There is no registration requirement for copyrights, and the National Library does not grant copyrights. Another second principle or basic principle, the dichotomy between idea and expression has been reiterated by recent jurisprudence. Ideas enjoy no protection, and hence no monopoly can attach to schemes, methods, procedures, and formats, almost similar with what you have learned in patents. Okay? And there should be no confusion about the ambit of protection afforded by different aspects of intellectual and industrial property rights law. Publishing a sketch, drawing, or a photograph and announcing that what is published enjoys copyright protection does not operate as patent protection of the items so sketched, drawn, or photographed. The only protection one obtains thereby, after publication, is against the unauthorized reproduction, distribution, or exploitation of the sketch, the drawing, or the photograph. So this particular slide attempts to elucidate to us, okay, what are embodied in one's copyright. Also, a basic principle, it is not necessary that an entire work be reproduced in order to infringe copyright. If so much is taken that the value of the original work is substantially diminished, or the labors of the original author are substantially and to an injurious extent appropriated by another, that is sufficient in point of law to constitute piracy. Okay? Who is the author? The natural person who has created the work. What is a collective work? Work which has been created by two or more natural persons at the initiative and under the direction of another, with the understanding that it will be disclosed by the latter, okay, who they are under control, okay, under his own name, and the contributing natural persons will not be identified. Okay, mahirap ang collective work, no? Okay. Joint work. Work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. So, siguro chapters 1 to 5 sa'yo, chapter 6 to 10 sa akin. For example, medical textbook that is jointly authorized by 2 or 3 experts. Performers, who are they? They are actors, singers, musicians, dancers, and other persons who act, sing, declaim, play in, interpret, or otherwise perform literary and artistic work. Work of applied art. It is an artistic creation with utilitarian functions or incorporated in a useful article, whether made by hand or produced on an industrial scale. So what are the classes of protected copyrights? The Intellectual Property Code splits works that may be copyrighted into 17 classes listed from A to Q. While all the classes listed are specifically for copyrightable material, trademarks and other forms of intellectual property, depending on what it is, are covered as well. Patents do not have a category. Okay? So pay close attention to this. Patents, hindi po pwedeng copyrightable work yan, di ba? But there are cases whereby, okay, trademarks, okay, other forms of intellectual property, for as long as they are considered or included in this list, okay, then they may enjoy copyright protection. Okay. So, literary works, mahaba yung listahan natin. No? Ito yung mga may enjoy copyright protection. So, we have to take a look at the enumeration. Okay, so literary works. No? Literary works, these would consist of novels, short stories, poems, dramatic works, and any other writings, irrespective of their content. Kung sakali fictional or non-fictional, that wouldn't matter. Then, of course, musical works, whether serious or light, it would include lyrics, songs, song arrangement. Okay, pwedeng hati-hati yan. No? You're the author of the lyric, he's the author of the song. Okay. Buo. O yung song arrangement. Art products, artistic works, whether two-dimensional drawing, okay, or like paintings, like etchings, okay, lithographs, or pwedeng maging three-dimensional, okay, drawings, so sculptures, architectural work, artistic works po yan. Musical works, whether serious or light, nabanggit na natin yan. So, literary, musical, and artistic. Mahaba kasi sabi natin A to Q. Ito yung category. Come to think of it, sa categories, wala ka mapapansin talaga dyan na patents. So, works of applied art ulit. Ano na yan? Artistic, jewelry, lamps, wallpaper, furniture. So, those are examples. Even, can we include choreographic works as patentable matters sa Philippine settings? Okay. Maybe dito po sa may audiovisual, no? The one choreographer, the output itself can be done there. Okay. So, the following persons acquire ownership by intellectual creation. So, intellectual creation is one of the two modes of the original mode of acquiring ownership, no? So the author, with regard to his literary, dramatic, historical, legal, philosophical, scientific, or other work. Okay. Composer, as to his musical composition. The painter, the sculptor, or other artist with respect to the product of his work. Okay. So, kung isang trabaho man ito, madami po dyan ang may original contribution. And they will have to enjoy copyright. So, rights comprised in copyright. What are the rights when we have a copyright? The owner of a copyright in a protected work may use the work as he wishes, but not without regard to the legally recognized rights and interests of others. Okay? So, the use of property, okay, bears a social function. Parang ganun din, no? So, no ownership is ever absolute. It is always restricted or limited by natural, by law, or by agreement, no? So, technically, the property owner can exclude others from its property without his authorization. Okay, yan madaling intindihin pag tangible yung property, no? Pag nakikita. Pero paano nga ba siya pag ang usapin ay property na intangible o walang body? Rights bestowed by law on the owner of the copyright in a protected work are frequently described as exclusive. Okay, see there the term exclusive. Okay, so what does this actually mean? Okay, it authorizes others to use the protected work, okay, but provided, of course, it must come from the original owner. So, ito po yung example po ng mga copyright or economic right. No? It shall consist of carrying out, authorizing, or preventing the following acts. What are they? Reproduction of the work or substantial portion of the work. Dramatization, translation, adoption, abridgment, arrangement, or other transformation of the work. And we have the first public distribution of the original and each copy of the work by sale or other forms of transfer of ownership. Okay. Still, to continue on our list on copyright or economic right, we have rental of the original or a copy of an audiovisual or cinematographic work. A work embodied in a sound recording, a computer program, and all the rest that we have mentioned a while back. Even public display of the original or the copy of the work. Even public performance of the work. Other communication to the public of the work. Moral rights. How is this moral rights to be exemplified? The original authors of works, okay, they are protected by copyright, also have moral rights, in addition to their exclusive rights of an economic character. What is meant by using a work protected? Most copyright laws define the acts in relation to a work which cannot be performed by persons other than the copyright owner without the authorization of the copyright owner. Such acts requiring the authorization of the copyright owner normally are the following. You have copying or reproducing the work, performing the work in public, making a sound recording of the work, making a motion picture of the work, and broadcasting the work, translating art, adapting the work. Okay, so rights of reproduction and related rights. Ito din ang bundle of isa sa mga nakalagay dun sa bundle of rights po ni intellectual property owner. Okay. So the right of the owner of a copyright to prevent others from making copies of his works is the most basic right under copyright. For example, the making of copies of a protected work is the act performed by a publisher who wishes to distribute copies of a text-based work to the public, whether in the form of printed copies of digital compact CDs. The use of the phonograph producer to manufacture and display or distribute the compact disc CDs containing recorded performances of musical work is based in part on the authorization that is given by the composer of such works to reproduce the composition in the recording. Therefore, the right to control the act of reproduction is a legal basis for many forms of exploitation of protected works. So you, being LSB, should now know that you cannot do this without getting the authority or approval of the content owner. What is derivative work? It is a new original product that includes aspects of a pre-existing already copyrightable work, also known as a new version. Derivative works. Okay? And derivative works can include musical arrangements, motion pictures, or art reproductions, sound recordings, or translation. So now let us take a look at another set of copyrights ownership. Okay, yung ating copyrights set of translation and adoption rights over his work. Meron tayong tinatawag na derivative works. So, the acts of translating or of adopting a work protected by copyright require the authorization of the copyright owner. Okay? This should always be remembered. So when one does translation, ano ba ibig sabihin ng translation? It means the expression of a work in a language other than the original version, no? Okay? Or when a person does adaptation, where adaptation is regarded as understood rather as a modification of a work from one type of work to another. For example, when you adapt a novel as to make a motion picture, or the modification of a work so as to make it suitable for different conditions of exploitation. For example, adapting an instructional textbook originally prepared for higher education into an instructional textbook for students at the lower level. Adaptation po yun, no? So translation and adaptation, okay, they are themselves works protected by copyright. Therefore, in order, for example, to reproduce and publish a translation or an adaptation, the publisher must have the authorization both of the owners of the copyright in the original work and the owner of the copyright in the translation or the adaptation. Okay, so to connect that translation and adaptation, ito yung transformation, ito yung underlying principle of derivative works. And this is the definition of a derivative work. It is created either by the author or the licensees with the author's permission, but always with permission from the author of the work. And it is created without the author's permission. It is legal if it will only be covered by the fair use doctrine. Okay, so by exception po lang yun, fair use doctrine. Pero ang general rule natin, derivative work, because it is covered by yung nga sinabi nating set of rights na isang copyright, then doing so without the permission of the copyright owner will be a violation of his rights and will give unto the owner of the original work those set of remedies to go after copyright infringement. Okay, let's continue. Derivative work. May mga klase tayo ng derivative work. So the first kind of derivative work is this. Okay, through their copyrights, the authors control reproduction and distribution of their works, although subject to rights granted to licensees. The authors also have the exclusive right to prepare or authorize derivative works based upon the copyrighted work. It involves transformation to another medium. This is the first kind of derivative work. So ito yung mga examples natin ng mga papasok po dito sa first kind, and I think you're familiar with them. I have not updated this slide for current examples, but basically I think you will get the sense of it. Okay? So nagsimula yan sa isang original work bago po nagkaroon ng ganitong klase ng derivative work. The second kind of derivative work, it uses the original in such a manner that it is not an infringement of the copyright. Authors are entitled to all the rights afforded under copyright law, but not to the exclusion of the public good. So, dito papasok yung mga exceptions to the general rule. Okay? Kasi nga, it is grounded on public good. Okay? So, tingnan natin itong mga second kind examples. Digitizing books is deemed to be considered as fair use for the intended purpose of augmenting public knowledge. So, yung sinasabi ng Google. Google has not copied the works for themselves but for the purpose of establishing a searchable database. Again, exception under the fair use doctrine. What else? Ang klase pa ng isang second type ng derivative work. Parody, spoofs. When a secondary work quotes an original for the purpose of parodying it or discrediting it by exposing its inaccuracies, logic, or dishonesty, such an undertaking is not within the exclusive prerogatives of the rights holder. It produces a fair use. It does not violate copyright law as long as it doesn't damage or harm the reputation of the original or try to pose as the original. Okay? So, I think you can still search on additional derivative works that would fall under the second kind. And if it will fall under second kind, parang kasama na din siya nung open source na sinasabi natin, all grounded on public good or exceptions such as fair use doctrine. Okay, natin. Next, what about on the matter of this set of works, computer software? Okay, when we talk about software, it would refer to programs and databases. Okay, and these copyright software are protected by copyright. Okay, they're protected by copyright. So from the moment of creation, yes. What about yung hardware? It is not protected by copyright, but rather is protected by patent, yung hardware. Okay? So, the reason for protection of by copyright in software, the economic right of the copyright holder of software programs, however, is limited by the right of the legitimate owner of a copy thereof to produce what is known as an archival copy. Okay? As well as adaptation rights such as what owners enjoys. Okay? Dito po yung restriction ng kanyang copyright over this particular computer software. Okay? Tingnan po maigi. Archival copy. Which works then are not protected by copyright? Yan yung next question natin. Okay? So, no protection shall extend under the law to, you've mastered this. Any idea, procedure, system, method or operation, concept, principle, discovery, or mere data as such, even if they are expressed, explained, illustrated, or embodied in a work. News of the day and other miscellaneous facts having the character of mere items of press information. Any official text of a legislative, administrative, or legal nature, as well as any official translation thereof. Okay? So, hindi po protected yan ng copyright. So, pag nagda-download kayo ng mga, official text ng mga batas, yung mga full text din ng mga cases, okay, there's no copyright infringement there. Okay? Yan. You could come out with your own acronym to remember this. Kasi all others will fall under the general rule and will be considered as having copyright. Yan. Isa-isang example natin doon sa ating works not protected. Okay, for number 1, an example of that would be the format of a television game show that is not subject to copyright. Okay, this is something to do with the TV program of Willie Revillame before. Okay, I'm not so sure anymore ano yung title ng TV program niya yan. But this was the finding. It is not subject to copyright, the format of the show. Okay. On news of the day, the writings of a columnist in a newspaper is subject to copyright, yung kanyang article. Okay. But if it mentions a news item, okay, the mention of that news item, you cannot claim protection regarding this news item. Ano yung official text? Nagbagan natin, unprotected works. Any work of the government of the Philippines. Kaya ito yung mga open source na pwede kang mag-research, no? Copyright gives no exclusive right to the art disclosed, but only to the expression. Because we're talking of copyright, not to the art disclosed, because it may be governed by another, but only to the expression. Copyright over an illustration of a hatch door does not protect the hatch door itself in copyright. Okay? Only po the expression. Take me to this. Not the idea, but the expression. Not the art disclosed, but only the expression. Who owns the rights to a copyright if the work is literary and artistic? So, literary works, artistic works, sino daw may-ari? In the case of original, literary, and artistic works, copyright shall belong to the author of the work, In the case of works of joint authorship, the co-authors shall be original owners of the copyright, and in the absence of agreement, their rights shall be governed by the rules on co-ownership. If a work of joint ownership consists of parts that can be used separately, and the author of each part can be identified, the author of each part shall be the original owner of the copyright in that part that he has created. No? Haba, pero I hope it would explain to us paano natin delineate kung sino yung author ng ganito, okay, ng original part of that code. Who owns the rights to a copyright pursuant to a commission? In the case of a work commissioned by a person other than the employer of the author, and who pays for it, and the work is made in pursuance of the commission, if the person who so commissioned the work shall have ownership, it is the person who so commissioned the work that will have ownership of the work. But the copyright thereto shall remain with the creator unless there is a written stipulation to the contrary. Okay? So, tingnan maigi kung ano yung tinatanong sa inyo. Sino yung author nung commissioned work? Sino yung author nung mismong original? Okay? Sino may-ari nung author nung tinawag nito? Copyright doon sa ginawa. Okay? So, general rule, creator. Kung sino yung creator. Pero yung commissioned work, magkaiba po ito, no? Pagdating sa usaping patent. I hope you see the distinction between the rules when we talk about this one. Okay? Because we were able to actually identify the commissioned work separate and distinct from the person who created it. Okay? Who owns the copyright when the work is an audiovisual, like a movie? In the case of an audiovisual work, the copyright shall belong to the producer, the author of the scenario, the composer of the music, the film director, and the author of the work so adapted. Okay? Yun na po maigi. Kasi nga, ang daming component ng audiovisual. Okay? So, we attribute each work, each part of the whole, to the creator of that particular portion. Who owns the rights to a copyright where the author is an employee? In the case of a work by an author, during and in the course of his employment, the rules stated on patent, okay, yung rules natin sa patent as we have mentioned in the previous video, that will apply. Okay? Simpleyado. Who owns the rights to a letter that was sent to someone? In respect of letters, the copyright shall belong to the writer, subject to the provisions of this particular provision of the new civil code. Okay, 723. To the writer. Ano sabi sa 723? Okay, that letters and other private communications, okay, in writing, they are owned by the person to whom they are addressed and delivered, but they cannot be published or disseminated without the consent of the writer or his heirs. Okay, so let us take a look at this particular bullet. Letters and other private communications in writing are owned by the person to whom they are addressed and delivered, yung mismong output the letter, but they cannot be published or disseminated without the consent of the writer or his heirs. Okay, so siguro alaman din ito. Example nito yung mga pelikula, no? Na kunyari ay na nagpapakita ng mga scenario that a letter was received, it was opened after a century, but should the contents, although we know that of course the writer of that letter has already long passed, okay, and that the letter is owned by, of course, the person who received it, but can it be translated or adapted into a new output like a movie, okay, without getting the permission of, not of course the deceased writer, but the heirs of the deceased writer? Hindi kailangan talagang kunin. Okay? However, the court may authorize their publication or dissemination. Again, exception to the general rule if the public good or because of course, promoting interest of justice or it is a requirement of justice. So this is the general rule pagdating po sa tanong ng copyright protection. Okay, so technically the rule would be modified depending on the kind of the protective work. Pero a general rule as it is that copyright protection for artistic, for literary, derivative works, balik na rin na lang natin para maalala natin, copyright protection for L. L is literary, A, artistic, D, derivative, LAD, derivative works last for the life of the author, okay, plus 50 years after the author's death. So, kunyari, yung ating work, LAD, okay, was created, say for example, when the author was aged, okay, kaka-18 pa lang niya, and he happened to survive until the age of 90. So during his lifetime, plus another 50 years after his death. Okay, it's a general rule. Okay, I guess it's about time for us now to talk about this exception to the general rules on copyright protection that are enjoyed by original creators in doctrine of fair use. Okay, so under Section 185 of the Intellectual Property Code, it provides for fair use of copyrighted material, and fair use admittedly is one of the exceptions to copyright protection. So the criteria for it to be considered as fair use, it is identical to the fair use doctrine that United States copyright law adopts. Okay. With the exception, ang Filipino component o tweak natin dun sa exception is that even unpublished works qualify as fair use under Philippine copyright law. Unpublished, okay, you have not yet published it. It's still, okay, falling under fair use under Philippine copyright law. Okay? So you work on an unpublished work of another. Okay? Kasi nga, the contention there is that it's still what? Okay, it hasn't been known to the public. So, ibig sabihin, hindi pa alam kung ano yung works ng bagay na iyon. Anyway, I might be rambling on this. Okay? But take note that, okay, we recognize a similar doctrine, okay, in the Philippines, the doctrine that is similar to the United States. But of course, we also now extended, okay, brinoden nating exemption by adding unpublished works, okay, to our enumeration of fair use. So, ito yung mga examples natin ng fair use of reuse, no? When you quote from a protected work, take note, quoting, okay? Quoting meaning you have to attribute that it is not from you, provided that the source of the quotation and the name of the author is mentioned, and that the extent of the quotation is compatible with fair practice. Okay? What else? Examples of reuse. Use of works by way of illustration for teaching purposes, and the use of the works for the purpose of news reporting. Okay? News reporting, teaching, and then attributed work. Factors to consider to determine whether use is fair or not. Number 1, what's the purpose? What's the character of the use? Number 2, the nature of the copyrighted work. Is it factual or is it creative? Number 3, the amount and the substantiality of the portion used. Number 4, the effect of the use on the copyrighted works market. Okay? Siguro ngayong online, nararamdaman ng mga estudyante o nakikita ng mga estudyante yung typical examples po ng mga materials under the fair use doctrine. Okay? So, protected from copyrighted work. But of course, ang contention natin dyan ay hindi lang po dahil purpose na establish mo na kagad na okay, your use is fair. You still have to consider some more. Okay? Baka naman buong libro ay ginamit na. No? And technically, that's already infringement of the copyright of someone, of the original owner or the original creator. Let's take a look at this problem. Center Bookstore is the publisher of the book Legal Journal. It donated one copy to the library of UE, College of Law. The library, in order to preserve the original book, they reproduced one copy for the journal for lending to the university students for own use. Is the university law library liable for copyright infringement? Yung pag-preserve ng reproduction ng isa. Tapos pag allow ng 1 copy for room use. Copy for the journal is marked for room use only and is therefore not made available to the public outside of the library. Okay, room use. Okay. Let's now highlight some of the more important parts of the law on copyrights. Literary, scholastic, or scholarly, scientific, and artistic works, whether published or unpublished, may be copyrighted. Pero sinabi nga natin, yung hirap dito sa unpublished, under the fair use doctrine, okay, they are now covered. Copyright protection extends to computer programs, multimedia works, and databases that are original by reason of the selection, coordination, or arrangement of their contents. Okay. In general, copyrights endure for the lifetime of the creator and for 50 years after his or her death. Okay. Let's now make a comparison of our different copyrightable works and the validity of the period of protection. Ito yung sinasabi ko sa inyo na may mga special rules tayo na na-apply depende sa klase po ng work. Okay? So, for the literary works, okay, ito yung application ng general rule during the lifetime of the author plus 50 years after death. For arts, okay, artistic works, however, tinan nyo maigi, okay, magkaiba po, okay, the validity period is not 50 but 25 years from the date of the creation. The art enjoys 25 years from the date of creation protection from copyright. Okay, no mention of death or whatsoever. Photographic works, huh? Okay, 50 years after publication. Audiovisual work, 50 years from publication. Okay, tingnan po maigi. Okay. Derivative works during the lifetime of the creator and for 50 years after his death. So similar with literary. Joint naman, joint creation during the life of the last surviving author and for 50 years after the death of the last surviving author. Pag joint, ang pinag-usapan natin, ang ating pong reckoning period will be gaano kahaba. Yung buhay po nung huling surviving author. What about anonymous, pseudonymous work? Ito yung mga gumagamit ng ibang pangalan, okay? O hindi natin alam kung sino ang may-ari until the end of 50 years following the date of their first publication. The 50-year duration commences from January following the date of publication. This is a special rule, no? Kunyari kunyari lang na yung work was published today is September 13. Okay? So, kailan natin i-recon yung 50-year po? It's not September 13, 2020, but sabi dito, from January 1 following the date of publication. It will be counted from January 1, 2021. Okay? Okay, ito yung certain tweak po ng ating pag-count. Broadcast. Okay, 20 years from the date of broadcast. Let's now go through some problems. Can an article of commerce serve as a trademark? That's part 1. And at the same time enjoy patent under part 2 and copyright protection under the rules that we have just finished. Explain and give an example if your answer is yes. Tignan natin. Paano natin sasagutin to? It is referring to an article of commerce. Article of commerce. Yes. A stamped or marked container of goods can be registered as a trademark. Okay? Now, pag-isipan natin ano ba yung special klase ng botelya. Ng botelya or ng isang packaging. Okay? Bottle of a soft drink maybe, di ba? That alone can be registered as a trademark. So whenever we see that bottle and its shape, we actually distinguish it as the as pertaining to a particular product of this, okay, of this entity. Okay. An original ornamental design or model for articles of manufacturer can be copyrighted. Yung original design. Okay, yung model, yung sample. An ornamental design cannot be patented because aesthetic creations cannot be patented. However, it can be registered as an industrial design. Kung hindi siya papasok sa invention, hindi din siya papasok siguro sa tawag nito, sa utility model, baka papasok siya ng industrial design. Thus, a container of goods which has an original ornamental design can be registered as a trademark, can be copyrighted, and can be registered as an industrial design. Okay? The industrial design is a lower kind of an invention because it would enjoy a shorter period of protection under patent law. Yan. So, lahat pwede sa isang example na ganito. No? Let's now talk about remedies. What if we have a case of copyright infringement? Okay, ano po yung mga remedies that the owner of the copyright is entitled to? Number 1, injunction to prevent the infringement. Injunction po. Damages, which is assessed on the basis of the proof. You have to prove your entitlement to damages. Okay, by whom? By the plaintiff. Okay, ano ipapresent niya? Sales made by the defendant. Okay, yung kanyang akusado of the infringing work minus whatever cost the defendant may be able to prove and appreciated by the court. Okay, yung kita, kasi dapat sa iyo yan, pero iba yung kumita, pero i-deduct natin whatever cost that. Sabi nga dito na valid na in-incur ni infringer. Yan. Another, delivery under oaths of all the implements employed in the production of the infringing products themselves and the infringing items for impounding or destruction as the court may order. Para hindi na ulit mag-infringe. Okay? Payment of moral and exemplary damages in the discretion of the court. And, okay, of course, there is that option to file a criminal action. Let us